Good afternoon, everybody. We're going to start now. I wanted to reiterate, unfortunately, Mr. Bhumesh Verma is unable to join us today because he got called into a very important and urgent meeting. However, instead of disappointing the students, we thought I'll conduct the session. I know I'm a very poor fill for those big shoes, but I'm going to try and my best. We are going to look at the fundamentals of contract drafting today, and we are going to basically, because it's Easter, also do an Easter egg hunt during this entire process. Um, am I audible to all of you? Is everybody able to hear me? Okay, that's great. And see me. Okay, that's awesome. Okay, so what we're going to do today, just to sort of, set you up with regards to what is a contract. I think most of your law students and most of you have some idea of what is a contract. Typically, our contract has a bunch of provisions, right? We say the way we've learned contract, basically we learn it as a legally enforceable agreement, which is, what do you say, which has elements like communication of an offer, acceptance of an offer, communication of the acceptance, um, that there is a set of reciprocal promises, that there is a consideration underlying it. We learn it from the concepts of the fundamentals when we learn it in college. What is a contract, right? How this translates into a written contract, how this translates into a transaction, that is exactly what we are going to deal with. You have to realize that you cannot still, ignore the fundamentals. A lot of people say, oh, there's a huge gap between, the way law is taught and the way law is, practiced. There is a difference between the industry and the, people. What you need to realize is, at the end of the day, be it the industry or be it the people, when we are looking at your, what do you say, the fundamentals of a contract, they still need to exist. They still need to be provided for within the framework of the modern terminology. So, what are the typical transactional contracts, right? So, you have an MSA, which is called a Master Services Agreement. You have a statement of works or a service level agreement, which come under these MSAs. You have NDAs, you have licenses. Now, there are other types of contracts like purchase of property, sale of property, etc. I'm not going that much into those. I'm only looking at transaction-based contracts today. That too, it's literally a brief overview. We are not delving very deep into it just yet. This is more to set a tone for future such workshops where we will be delving very deeply into each of the topics. Okay, so first let's understand what is a master's services agreement, right? A master's services agreement is almost an umbrella agreement. It contains all the basic terms and conditions which are going to govern any future agreement between the two parties. Now, when does this happen? For example, I'm Infosys and you are IFIM, and you wish for me to provide you internet services, software services in various forms for each of your branches that you have across the country. So, for each place, a separate service agreement will be entered into, which is called an SOW or an SLA, depending on what we want to go down the road of. But all of these agreements would be between Infosys and IFIM, the main bodies, where they are laying down certain terms and conditions which will be applicable to the SOWs and the SLAs. So typically, where you're contemplating a long-term relationship between the two parties. Second, where you're contemplating that the two parties, when they do enter into this long-term relationship, there will be minor chunks of work that will be governed by specific contracts to that. Those minor chunks of work would be an SOW or an SLA. All of those combined together is what gives you your SOWs and SLAs. MSA is entered in that scenario. Okay, so typically what does your MSA contain? Service overview. What all are the services that an organization thinks it might take from another organization? Payment terms, this will not be one specific payment term. You need to realize payment terms come in various forms, animals, methodologies. Payment terms are, what would be the rate, what are the slabs, what is the discount, if any, that are applicable, when are the discounts applicable, what happens when there is a failure to pay, what happens, when does an invoice get raised, and what happens when there is a failure to pay. All of these typically comes into your payment terms, and that is also given in the master services agreement. Then there is processes for audits given in the MSA. Basically, it lays down that when you go through as a client, I want to have insight into how you're going to be doing my work. If we are entering into a year long or a 2 year long contract, I need to make sure that you're not veering away from what I need done. So, what is it from your end that you are going to show me as proof of the fact that you're actually following what is required? So, for example, when I was working in the LPO segment, one of the things we used to give is known as a daily report and a weekly report and a monthly report, right? The daily report would be at a project level. This is the amount of work we have done. This is our, defect seepage. This is our error metrics, and we used to send it to them. A monthly report would be across, a weekly report would be across 2, 3 projects that were at that time active. This is the scenario. This is active. This is the level covered. This is the work pending, so on and so forth. This was a method for them, for our clients to have insight into our work. These kinds of audit systems are already set up in the MSA. Now, the second thing typically also is your confidentiality terms. You need to realize almost all business have very critical data that they wish to protect, and that is your confidential information. Now, you do study confidential information as a part of your intellectual property rights also, but you need to realize that confidential information is critical for the survival of a company. Now, what are confidential informations? Client list, formula, secret formula of Coca-Cola, that's a confidential information. Who's our distributors, what is our source of information, who are our employees, who are our students. All of this is confidential information. We can't just share it willy-nilly. We can't just give away this kind of information. So this kind of information you need to provide for a protection mechanism within any agreement that is entered into. Is this apart from your NDA? Yes. The NDA is a general non-disclosure agreement in that it lays down that you cannot disclose anything during this transaction, even before the contract has been entered into. For example, an NDA may be entered into in the case of a merger and acquisition that is proposed. In the end, acquisition may not happen, but the NDA still remains in place, right? So NDA is independent of the confidentiality terms that exist in the master services agreement, because the master services agreement lays out that your NDA, your confidential information cannot be shared. And this confidential information is what might be shared during the course of the services being provided, but you cannot utilize it in any manner whatsoever. Then you have your warranties. Now, we are going to discuss in detail the difference between what is a warranty, what is a guarantee, how do we need to draft it. For now, just understand that it's a promise, it's a representation made by the service provider saying, I will do this, this is what I'm promising. That is a warranty. Okay. However, what it does not include, your master services agreement does not include a process of service delivery. With me so far? Yes, no, maybe. Anybody has any questions? So warranty I will explain again in greater detail, Mr. Biswas, but basically for now just understand it to be a representation. Okay, we are going to do warranty in greater detail in 2 minutes. Just hold on to your hat. Okay. Anybody else has a question? Okay, so moving forward. Next, we look at the statement of work, or SOW, right? Now, what is a statement of work? It's the child of a master services agreement, right? It's the baby. What it does is it basically has all, it by implication includes all the terms of the master services agreement, but it is with regards to one specific project. What is the, the size of the project, what is the length of the project, what are the results to be achieved, then what are the stages of the project, what are the deliverables with regards to the project, the deadline, the costs, the KPI, which is your key performance indicators, and what is, the exact task that is being set out. So where the master services agreement is general with regards to these are the services, it's like a menu card. It says these are the services that are being provided. You may choose what you want to. All of these services will be provided to you under an SOW. Then you will say, ma'am, how is that an agreement? Right? Good afternoon, Dr. Rajesh. When we look at your scenario of a master services agreement that has, terms and conditions included in it, you need to realize that the terms and conditions are binding. The consideration is flowing. So it is not that because it's a menu card, it stops, it's only an offer and it is not an agreement. It is still an agreement because there is a promise that at a later date with an SOW, I will be consuming the said services. So when we look at the SOW, I just quickly want to explain how KPIs work and project stages and project deliverables work. So if I'm a factory that manufactures shirts, right? And each of the shirts that I'm manufacturing, so you are a retailer who wishes to sell those shirts. You want, now it's summer season, you want t-shirts from me. So you have placed an order for t-shirts. In my master services agreement, I will say I will take care of all of your shirt requirements, be it casual shirts or non-casual shirts. So you say, oh, now it's summer season, we need more t-shirts, we need more colored t-shirts, so please give me colored t-shirts. You raise an SOW with that. In that, you would have how many t-shirts do you want? By when do you want it? Do you want all of it in one go? Do you want it in stages? What will be the cost of each of the t-shirts? What will be the form of transportation? Who will take care of the delivery? When will it be delivered? This would typically be in your SOW. Your MSA would be holding terms like who will insure the goods during transit, who will insure the goods upon travel. Very expensive. How, Purvi? So when we look through the t-shirts and the shirts scenario, you need to realize the SOW does take care of that. Next, we come to service level agreements, which is SLAs, right? SLAs is very, very clear. It lays down what should be the metrics of what you're delivering. So if I am delivering t-shirts to you. Yes, but generally it is a part of the cost itself. Yes, with transportation and middlemen, typically, yes, goods would be considered expensive. You need to realize it's the quantity versus, the economics of massive quantities to the amount, to the ratio of the transportation that makes it cheaper. So all of that would make it affordable, and that's why you do get t-shirts for 100, rupees also, right? So coming back to our point, when we are looking at service level agreement, you need to understand that it basically is a step further than your SOW. A statement of work says, I want this, I want ABCD by this time in this manner, full stop. Here they go into further detail. They say, okay, we want ABCD, but ABCD should be of this quality. This is the quality check you will carry out to ensure that it is of this quality. So all of these become a part of service level agreements where they are not just talking about the work being transferred, it's what level of services are being offered. We want a good level, and that is what is being taken into consideration. So it also lays down what happens if your performance is below par. So if you have promised that, oh, out of 400 t-shirts that I deliver to you, maximum 5 will be damaged. And if 10 are damaged, then what is the implication? If I promised you a t-shirt made of, say, a certain material and I send it of a different material, then what is the liability? All of this will be laid down in the service level agreement. It will lay down what will happen if when you become liable. How the liability is going to be redeemed from you will be provided by the master services agreement. So we've understood, right? So you have your master services agreement, you have your service level agreement, and you have your statement of works. All of these are what is provided by the agreement. Now, when we look at an NDA, it becomes essential because this is something now we get employees to sign, we get lawyers to sign, we get auditors to sign, because you need to understand non-disclosure agreements are very simple. They say you cannot disclose anything that you come to know due to your relationship with the with the party during this transaction, whatever the transaction may be. So NDA is irrespective of a transaction. So if we go back to our basics of contract, what is the consideration underlying the NDA? The consideration underlying the NDA is that I will not disclose this information, irrespective of whatever information is shared with me. That is the consideration underlying the NDA. Now, can NDAs be perpetual? Can we have an NDA that is perpetual, that just never dies? Can I take a quick poll on that? Please cast your votes. So the no's seem to be winning. We have, okay, so we have 15 saying no and 7 saying yes. Shweta says it depends on each project. So first of all, let's understand what an NDA protects. If I am Coca-Cola and we all know the Coca-Cola recipe is a trade secret. And I've worked at Coca-Cola at improving the recipe, or I have worked on the Coca-Cola in the Coca-Cola company to sort of tweak the recipe to make it sugarless or less sodium or less aerated or highly aerated. So I've had to work on it, right? So in that case, can I have a perpetual NDA? Rituka, I agree with you. It depends on the limitation stated. I'm asking, would a limitation be stated? Um, does a duration clause have to be mentioned? That's the question we need to answer when we are getting an NDA signed. Typically, please remember, researchers, we don't want them to ever disclose what they have worked on. Coca-Cola recipe is not known for a simple reason. NDAs can be perpetual when the information that is shared with them during the entire procedure is so important and so critical to the work that we can never have them disclose it, right? Uh, Another thing you also need to understand is if my operations are what is unique about how I function. In case of trade secrets, yes. In case of operations that are unique or my client list, can I ever disclose it? No, I cannot disclose it. Some parts of the NDA will, or most of NDAs can be perpetual. There are some NDAs that have durations that typically last during the course of your employment, 2 years post the course of your employment. In those cases, also, there can be a duration defined, but you need to see what is the exposure of that person with regards to what is being shared with them. That is critical to make this determination. So, this is a question that you have to ask your clients as lawyers. Dear client, do you want a timeline with regards to the NDA? Do you want it to expire at a certain point or not expire at a certain point? So you need to look at it from that perspective and then take a call. So typically, if I am Dr. Reddy's Laboratories and I am coming up with a coronavirus, anti what do you call it, vaccine, then that vaccine, I want it to be top secret. It's an intellectual property. Whatever work we have done, if we have gone down a certain road and been frustrated, you need to realize that is also confidential information. That is also something that may not be a patent, but at the same time is my intellectual property that I have the right to protect. At that time, we can keep it perpetual. Lower down the line, when you're in sales and marketing, typically marketing strategies, you want the NDA to be perpetual. But with regards to, the higher the position, the longer the NDA should be in force. The lower the position, the smaller the amount of time the NDA needs to be in force. But that's something you need to do after discussing with your clients with what is being shared with that particular person. With me so far? Shall we move ahead? Right? What happens if an NDA is breached? Right? The NDA itself needs to provide for it, basically saying, okay, we're going to blacklist you, we're going to terminate you, we are going to, sue you, so on and so forth. Enforceability of NDAs, now the courts are enforcing it, especially because we had a lot of jumping ship happening, especially in the software segment, where an employee would start working with one company on one software. Just before the launch or just before it was about to finish, they would jump shift for a better package and a better percentage to another company, and then voila, 2 weeks later they're launching it from there. So created an untrustworthy environment in the Indian employment force, where people said hesitated to pass on uh, secrets, etc. Ha, non-compete. Let's talk about non-compete clause. I was waiting for somebody to bring it up. Thank you, Ritika. So you need to realize non-compete clauses are a part of the employment contract, which I'm not dealing with right now. But just very quickly to let you know, it does exist. It also lays down a timeline for within which you should be able to not get hired by the clients or the competitors of the business that you're a part of. Now, the issue that arises is the courts have been waffling a little bit with regards to the non-compete clause because it also violates your freedom of trade. So, if they are generally timed, it is allowed between 3 years to 5 years, but then enforcement becomes difficult because how do you show? You have to realize confidential information is like water, it gets everywhere, and you don't know where the information is coming from, right? So you need to realize non-compete clauses, though valid in the contract, some courts have gone the other way a little bit. So our law with regards to non-compete is still a little bit up in the air, right? Now, how do we make sure that an NDA is bulletproof, right? First, get it signed, get it executed. A lot of times, what happens is, and this we've seen with experience with various industries, the HR is generally tasked with the idea of, with the task of getting the NDA signed. They forget to get it signed. So make it a part of the employment contract. Say that this has to be signed along with the offer letter. No two ways about it. The second thing, that it has to be stored properly. Third thing, within the NDA, do not allow for any loopholes. What is confidential information has to be clearly defined within the NDA, saying whatever is classified as confidential information and or information that is important or sensitive to the entity cannot be shared. You see how we have broadened the horizon, because sometimes you may forget to put confidential information on a particular document and share it. That doesn't mean I can the next day put it up on Instagram, or on WhatsApp, or on Facebook or LinkedIn. I still am bound, because I have said if it's sensitive or important or a part of the company's working, you cannot share it. So don't just restrict it by saying, oh, whatever is confidential information, whatever is marked confidential information. That is a recipe for disaster. That is how you secure your NDA and make it bulletproof. Uh, then let's talk about the other thing that typically arises in transactions, a type of contract, that's licenses. Now, when I talk about licenses, I'm not talking about government issued licenses like that for transportation or for liquor, so on and so forth, food, restaurant. No, I'm talking about licenses with respect to intellectual property. Typically, if, for example, you're trading, I'm manufacturing thumbs up, right? And you are retailing thumbs up. Both of us would have an agreement between each other whereby you will be allowed to use the trademark, the thumbs up trademark, right? This trademark you should have the authority to use. If you don't use it, then it becomes a problem. You cannot promote your own work. You cannot promote the fact that you're selling thumbs up. You can't even put up a sign. Only if people come and specifically ask for it, then you can give it to them. You can display the goods, but that's about it. You can't put up a sign that says thumbs up available here, cold thumbs up available here. You can't do that, because that would be a violation of the trademark. So licenses also become a part of typical transactions where intellectual property rights that arise are taken care of. Now you have to realize licenses can be standalone. In the sense, you can have you're J.K. Rowling, you're entering into license agreements with, well, now Disney all the time, because back then it was Warner Brothers all the time, to make your books into movies, right? But you have to realize that's a standalone license that involves a particular intellectual property right being given in a certain manner to the other party. The sort of license I am talking about is what is called as IPR clause in most contracts, where it basically lays out that if there are any intellectual properties that you are permitted to use, these are it. If you generally you're not allowed to use it without the prior permission or check or approval of the other party. If my intellectual property is being used by you, I should have the authority to say what you can use it for, when you can use it, and when you cannot use it, right? um, Generally both positive and negative are used to define the IPR clause. What do I mean by that? You positively state that you can use the IPR when you're selling my goods. You can use my trademark when you're advertising my goods, but you cannot use it when you're advertising some other goods, or when you're advertising your business in these kinds of fora. I'm not going to allow you for it. So you have to define these sort of licenses, semi licenses that you're giving through the IPR clause in very clear terms, right? Because we've had scenarios where, for example, somebody who hadn't registered a trademark and had just put in an application for it. Their trademark was being bandied about left, right, and center, and one of the service providers, in fact, took the trademark um, away. Now, you need to realize in an IPR clause, typically royalty is not provided for, because it's not that you're licensing away the IPR in the strictest sense of the word. They are not earning because they're using your trademark for advertising, literally. And how do you measure it, right? I am an Apple, Apple store, or I'm an iStore, right? How does that in any way help you figure out what would be the royalty? If I advertise it in the paper, how do you figure out the royalty? I am using it. So typically here, royalty in the IPR term will not be there, but in a typical standalone license agreement, it's 3/4 of the license agreement. What is the royalty? When is it payable? What percentage is it? If the sales are this much, how much? If this is sales are this much, how much? All those slabs are also given. Any questions so far? I hope all of you are with me. Okay. So What happens when the IPR is breached, when you exceed whatever has been given by the IPR clause? That also needs to be a part of the IPR clause. If you use my trademark or my copyright or my design without my permission, I should have the right to penalize you, and that should be provided for within the IPR clause itself. The language of the clause therefore becomes very important. How do you draft it? What do you state in it? So on and so forth. You need to realize most of the times you typically say, oh, during the execution of the contract, party A has the right to use party B's IPR as the case may be, with the requisite consent of party B, right? And full stop. You can't stop there. No, you have to continue. In case party A does not procure such consent, this is the liability. In case party A procures the consent but exceeds the amount of consent given, this is the liability. That needs to be very crystal clear in a contract. One of the things I wanted to state right at the beginning, but I think I will keep reiterating it throughout to drive the point home. A contract should be such that litigation is the last thing that either party thinks of. Do you want me to repeat? Hello? A contract should be so well drafted that litigation is the last thing that any party to the contract thinks of. They should have enough detail in the contract, enough, shall we say, ability to resolve all the issues, that they shouldn't have to resort to litigation. This is what we call the difference between firefighting and fire prevention. Your contract should be fire prevention, not firefighting. Yes, arbitration clause is most important, and we will discuss how beautifully that can also be drafted and how badly also that can be drafted. Okay? So your typical contract has these clauses, and we're going to discuss these each in detail. So you have the parties, you have the scope of service or goods being exchanged in terms of payment, term and termination, liability, and your bis major or force majeure clause, your guarantee, your warranty clauses, jurisdiction, dispute resolution, and confidentiality. So why is parties important? You need to know who the contract is between, right? So party A and party B needs to be clearly defined, and only then can it be utilized, right? So you need to also designate each of the parties and stick to that designation. Now, unfortunately, in our careers, we've come across lawyers who are not very ATD, big on attention to detail. So they have made mistakes where, they have started out saying, party A and party B. Then suddenly it becomes seller, buyer. Then it becomes agent, principal. So stick to the term that you're defining them as in the parties. Use that very terminology throughout with the proper capitalization. If you're saying the company, you should say the company throughout. If you're saying the person, then you should say the person throughout. It is extremely important that this is followed at all times. It's critical, because it becomes very confusing to read a contract later if you mess up on this part, right? The parties generally also has, so typically the language is, so and so and so and so are entering into a master services agreement on such and such date. Your date of commencement comes from the parties clause, and that is again important because that is when you start calculating the term of the contract, which is another very important aspect of the contract. And what happens if the name is wrong? If I have got, so my company's name is, let me take a beautiful name, hold on. So Stuti Desai Moorchung of Moorchung Family Enterprises Private Company Limited, right? Bombastic name. Now let's put that down. You miss one word in my name, or worse than that, you miss say, or you misspell the name. Under Companies Act, we have seen cases where if the company's name is not put properly, the company can later on turn around before the execution or the performance of the contract, can turn around and say, I'm not obligated to fulfill this contract because that is not me. And then the directors become personally liable. So it is critical that you put the name correctly as it is in the certificate of incorporation of the company, in the case of companies, as it is in the partnership agreement of a firm, so on and so forth. Look at the document, find the name, and then put it in. As lawyers, this is our job to pester till we get that particular document to make sure that we put it in correctly. It is critical, right? One of the cases where if you leave it out or you mispronounce or you use an acronym, and best is to visit the MCA website, but you have to pay for it. And sometimes you don't get the correct document, and because you don't know whether you're dealing with the holding or the subsidiary, it's better to get it from the company that you're dealing with directly. It's free in the sense, but going to your memorandum of association, your articles of association, your certificate of incorporation, for instance, you need to make sure that the branch you're dealing with is the correct branch. So yes, you have to register and then get it, and that's a complicated process. Better to get it straight away from the company itself. MCA is the second best option. Agree. MCA website is extremely useful and one of the greatest resources, but you may not always be dealing with a company. You might be dealing with a shop. You may be dealing with a sole proprietorship. So whatever is on their tenancy agreement, you need to use that. Whatever is the way, or their PAN or GST, identification. That's another go-to place to figure out what is the correct name of the enterprise and enter that. Okay, so let's start an Easter egg hunt because this is Easter. I'm going to throw a question out here, and you guys have to look through and tell me what is the mistake. So, because somehow the whiteboard is also giving heart, I'm going to uh, individual has used. So Shweta has a question: if individuals have used different names, then how to deal with it? So if you're looking at an individual person and they've used different names, you go on what is in their Aadhaar card, because that is the accepted identity proof right now. And the issue that arises is if they're known by multiple names, typically we advise our clients, go get your name change done ASAP and get it saved on, through various mechanisms, and get all of your documents to say the same name. But if it doesn't, Aadhaar card is your number one go-to, not even the PAN card nowadays, unfortunately, right? So here's your Easter egg hunt number one. Why doesn't it show in black? Hold on, sorry. Can you see through the comments? Can you tell me what is wrong with this? So I have two questions. Why do we need to give us the correct address? And second, what is wrong with the parties that I have provided for here? Let's see if I can put that on the whiteboard. Hmm. You should be able to see it on the whiteboard now. I just unwrapped it. Agency complete address is not provided. Address for service. Address of the agency is incomplete. And for what? Yes. That would come later in the contract, Jojo, but you have to give the full address. Why is the address important? Anybody? Why is the address important? Serving a notice. Absolutely right, Apurva. Whenever you have to serve a notice, you need, this is the first point of reference. You look at the office address given here, right? So whenever you're serving a notice, you need the address. Therefore, the full address does need to be mentioned along with the names of the parties. Is everybody clear? Does this help? Do you guys enjoy this? Okay. All right. Okay, so next let's move on to terms of service and payment. So this is your core of the contract. This is exactly why they're entering into a contract into the first place, right? So typically your terms of service would be what is the service, or what are the goods we are providing, when, where, why, how, what, right? Your These questions have to be answered. When being, when are the goods due? um, where do we need to do the delivery? What are the goods or the services that we are providing? What are these goods or services going to be utilized for? So the why, and how should the delivery be made? What should be the sort of expectations of the supplier, and what should be the expectations of the receiver, right? All of this comes into your terms of service, and they're very, very critical to understand how the terms of service will work out, right? So when you also need to realize the terms of service become even more important in, for example, cases of international contracts where you're doing international transactions, where you're delivering goods across borders, because you need to also sort of have terms which will also state when are the goods considered delivered, right? Is it when they have left my yard? Is it when they have been put onto the truck, or is it when they are on the ship, or is it when they've reached your shores, or is it when they've passed customs in your country, or is it when it has reached your doorstep, right? So you could have a delivery happening, figuratively, where we are saying from this point onwards, basically the liability for the goods are transferring from one party to the other. In local contracts, typically we assume the delivery is still when the goods reach the go down of the other party, or when the service that has been promised has been completely given, then we say the delivery has been made. That being said, if there are any unique exceptions, then you do need to clarify what is the delivery, when are the goods or the services considered delivered. Um, your terms will also include your payment terms. So what is your payment slabs? If you consume X amount of goods, this is the amount of payment. If you take this kind of service, this is the payment. So you would have, if in a typical master services agreement, your payment uh, sort of menu card would be pretty big and would involve all the services that they're willing to provide to the company. Then it also includes mode of payment. When should the invoice be raised? By when should the payment be made? How should the payment be made? All of these are covered in your payment terms. The way you word this is critical. You need to realize that, for example, if I say something to the effect of, once the invoice is raised, the payment is due. Does that mean the invoice doesn't have to be communicated? And is that fair? No. You generally say once the invoice is raised and communicated to the other party, then the payment becomes due within 10 days of the receipt of that invoice, right? So you need to make sure that the terms are clear. You can't use a word like due date starts from this point without actually specifying the act that underlies, that makes the due date come into existence. No, there is no statutory limits with regards to the amount of days by which you have to, pay up. There is 10 days, there's 30 days, there's 50 days. It's the love and affection between the two parties that kind of defines what's the amount of credit that they're willing to give. You need to realize it's all about trust in business. So it's dependent entirely upon the agreement. Where the agreement is quiet, your Sales of Goods Act kicks in, or your, and it basically lays down certain terms. But generally, nobody relies on Sales of Goods Act. They go more on their relationship. Somebody new that they're entering into a relationship with, they will give far lesser time for credit. Over time, after trust and faith is built, then the time for credit given is higher, right? Yes, purchase order generally mentions the time for payment, but you need to realize that the purchase order is a part of the SOW in that it lays down what are the goods. Your SOW can be a purchase order also in that sense. Sometimes your purchase order is an SOW. It's confusing, but it's there, right? Um, so term and termination again becomes very important because you need to understand contracts being perpetual. There is really nothing to stop them from being it, but it's impossible. So therefore, you should have a term or a termination clause provided. Now, you need to realize there is a difference between term and termination. Term lays down how much time the contract is valid for. Termination means either party wants to stop the contract even before the term has expired, then termination kicks in. Okay. So this is again something where you have to take inputs from your client with regards to what they want to do. Uh, do they want a term? How long do they expect the term to be? Is it a 1 year contract? Is it a 5 year contract? Is it a 10-year contract? So on and so forth. But while determining the term of the contract, please understand that you have to look at a few local laws to determine it. For example, stamp duty in Karnataka for commercial contracts is 100 rupees. That's about it. It doesn't matter what the terms are. However, in Maharashtra, it's slightly different. They look at the clauses of the contract to determine what should be the stamp duty. So you want to look at that particular, clause from the perspective of what would be the cost for the company with regards to registering the contract, right? Is this the same as a term sheet? So when you say term sheet, you mean one where the terms and conditions are laid out along with the term of the time? Jojo, I don't understand. Yes, the executed one depends upon the agreement, Jojo. Okay. So, yes, it is the same as a term sheet in that the term sheet would have your term and termination clauses included. With me so far? Do you need further clarity, Utsav or Jojo? Okay. So when you're looking at your term and termination contract, please remember it's not enough to look at it in from an isolated perspective. You do have to look at your stamp duty or any other liability that arises. Term sheet is a part of the MSA. It depends. In some MSAs, they would call it a term sheet. In some MSAs, they won't. You need to realize that the term sheet could also be just a part of the SOW because they may not have an MSA in place. So you can't say this is the rule and everybody is following it with regards to this. I'm just telling you, generally in the industry, it is like this. But what happens within the company is left to you once you become their general counsel. You call the shots. You can make your own set of rules with regards to all this, right? But you also need to realize you don't want to keep reinventing the wheel. So you do follow some of the industry conventions. Does that answer your question, Mr. Bishwas? Okay. So let's get our Easter egg hunt on again. I have a fun one here, and this is from a real contract, by the way. as an executed contract that we had the good fortune of coming across. Ay, ay, ay. You can't see it here very well. I'll paste it here also. Hmm. So you have to look for the goose egg in these Easter eggs. Guys, please answer the poll after reading the first paragraph. I have had only 13 responses. I'm looking at 40 participants, so I should have more responses. Did you guys answer? Do you want me to tell you where the mistakes are? Yes, no, maybe. Okay. So the first line itself has an error. This agreement can be terminated by any of the parties by giving 60 days notice in writing. To whom? Should I publish it in the newspaper? Should I publish it on my door? Should I wear clothes of my notice and walk around? You need to realize, you need to specify that whichever party wishes to terminate needs to notify the other party with a 60-day notice period. Then only you are clear. Otherwise, give in notice in writing to whom? It doesn't specify that. As lawyers, that's a loophole. We will not allow for it, right? And you have to also realize sometimes you want to have a designated person receiving the notice. You can't just send it, care of so and some random XYZ, care of AK Enterprises. You can't do that. So you need to sometimes even say designated person, identified person, a key person, so on. So who are, like, later in the contract well defined, so that they know that this is the designated person, that is the person I need to address my notice to and send my notice to. Then the second line, in the event of the termination or non-renewal of the agreement, neither party will pay any indemnity, and also in such event, the company is not bound to take back the stock of the dealers. This is foolish, because when you think about it, you're basically saying, dealers, go ahead. I'm not going to take back the stock, despite the fact that we are not renewing the contract, despite the fact that we are not going to, you know, or we are terminating the contract. Now you go ahead, sell those goods, keep the commission, don't pay me anything, right? You need to realize this is shooting oneself in the foot. One needs to make sure that it's equitable to both sides. So don't say that indemnity is not owed, definitely. But with regards to stock, think, stop, discuss with your client to identify what they wish to do with it. So if it is perishable stock, let them sell. Whatever stock is currently with the dealers, let them sell it off. The amount owed should still be remitted back. No further stock will be given. That would be a better language for this provision than what is written here. Um, so that's goose egg number two, right? And then let's look at line number three. The terminations or non-renewal of this agreement will not in any way affects the right of either party accruing on the day of termination or non-renewal of this agreement. I'm not being a English and a grammar Nazi here, but you need to realize each word in law has a critical role to play, and we cannot make grammatical errors or spelling mistakes, because that can change the meaning of what we wish to say. In this instance, it's incomprehensible what they want to say. They basically want to say, the rights of the party will not be accrued on the date of the termination or non-renewal of this agreement. What do they mean by that? What rights need to be accrued? You need to think it through before you make a general statement like that with regards to rights, right? So you need to realize this again, very badly drafted. What rights are they talking about? Rights that arise under this contract will accrue. Accrue meaning what? That they will have the ability to sue if there is a breach, or will they not have the ability to sue if there is a breach? This is very unclear in this terminology, and that is exactly why drafting becomes very important in a contract. Each word has to be read and understood from the perspective of both parties. And you know th- any contract you shouldn't blindly sign. Read before you do it. This is a case where instead of fire prevention, we are creating the fire, leave alone fighting the fire. A term like this, we are creating the fire, we are causing the problem, because we are not being clear with what the contract wishes to achieve. Now let's move on to this terminology, right? Either party shall be entitled to terminate forthwith on the happening of any of the following, right? We have stopped utilizing such antiquated terms like hereto, before, forthwith, etc., right? We only utilize it in the rarest of rare cases. Typically, this could be written better, but at least it is communicating what it needs to communicate, so we really can't criticize it that much. But as more and more international contracts become the rigor, it is important that we stop utilizing such prehistoric terms in our drafting. Uh, right to indemnify is the right to accrue, yes, but you need to also realize it's not just that, it's also the right to sue in case of breach, right to, indemnity, right to violations of confidentiality, all of those rights. Are they being accrued or not? That is not very clear in that sentence, the way it is currently, drafted. The last Easter egg to look through. So the grounds on which the termination can happen, right? Uh, you need to realize it's in direct contradiction to what it is stating in the first paragraph. Either party can terminate, and then it says, well, they are entitled to terminate in these circumstances. So the difference being, in the first paragraph, it is at the will of either parties. In the second paragraph, When this scenario arises, they have a right to seek termination, but it is not automatically a termination. So, what are these that they have given? And this is where it gets super fun because boy, is this a bunch of goose eggs, right? It's a whole nest. Let's look at it. Party may any arrangement or composition with creditors, or upon a winding up order being passed, or going into liquidation, voluntary or otherwise, or on a dissolution of the firm, or if a receiver is appointed of the property of the company, or any partner of the firm of the dealer. What? You need to realize they've basically tried to provide for a dissolution of a company, dissolution of a partnership, and bankruptcy of an individual. Classify it and put it systematically instead of making this, I think, want for a better word, khichdi of what this is, right? Because it doesn't clarify anything. If you're going into liquidation, you need to realize you're basically declaring yourself. I mean, that liquidation is a term we typically associate with companies. We don't talk about liquidation in the case of individuals, right? We talk about bankruptcy in the case of individuals. So if you are an enterprise which enters into an agreement with maybe an individual, with maybe a firm, or with maybe a corporation, whatever the situation, and you wish to provide for termination on these grounds for in each of these instances, if the other entity is a company, blah 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 blah, if the other entity is a firm, blah 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 blah, if the other entity is a is an individual, blah blah blah. That is exactly how you need to divide up the clauses to make it clearer. Here it is confusing, so it doesn't exactly help either of the parties realize what is going right or going wrong, right? So everybody with me so far? Shall we move forward? So this has now become the new thing to discuss, especially post COVID-19, and that is your liability clause. A lot of the companies are worried about what is going to happen. Can they invoke the force majeure clause? And there's a lot of discussion going on with regards to that because they're not able to fulfill their contractual obligations thanks to the lockdown, right? So when you look at the liability clause, you need to realize when does the liability arise needs to be defined, right? What do we mean by that? Uh, when will one party hold the other liable? Now, remember, we talked about payment not being made, right? That's a scenario where liability is arising. Who is liable to whom, right? Then, when you have non-performance, who's liable? And if they are liable, what is the next step, right? If there is a liability that arises due to third-party actions. So, for example, I am transporting, goods to you, and I'm using a transporter company, and that company has a bad truck, and the truck meets with an accident, the goods get destroyed. Then who is liable? These are the kinds of scenarios where the liability does have to be addressed, and there has to be a solution given, a resolution given, right? So you have to identify when does the liability arise. Typically it arises when there is a non performance, or when a third party intervenes in the contract, or there are situations where the liability arises because neither party is in control of what is happening, like it is happening now, where neither parties would generally have control over the legality or the situation that we are in. It's not that your contract is illegal, so therefore it's not void or voidable, but it is that it is impossible to perform, but it's not a frustration. So there is a lot of issues that is going on that need to be resolved, and from that perspective these clauses become very, very critical. So when you're doing your liability clauses, you need to be careful. Map it typically with your sales executives and your delivery executives if it is a goods company. If it's a services company, talk to the operations department to figure out what would be typically the issues with regards to delivery that they foresee. and which can be, mitigated well in advance, that if we fail to do this, this is what we're going to do. If we fail to deliver it in time, this is what we're going to do. If we fail to deliver it with this level of precision, then this is what we're going to do. This needs to be provided for in the liabilities clause, and it has to be done for both sides, not just your side but from the other side also. If they fail to pay, then what? If they fail to take delivery, then what? If they fail to um, accept the goods at a later date, then what? All of this does need to be included. So let's look at our Easter egg hunt for this one. So what do you think about legal recourse? Do you think this is a good provision, that there is no Easter egg in this? What is not right with it, Jojo? Exactly. They have to specify what legal recourse, but that could come in a later paragraph where you say that it would be alternative dispute resolution or whatever. They can say that it can be grounds for termination of the contract, or that a notice has to be sent. These kinds of things can be done. I think the issue also is, if the service is not provided within the stipulated period, you're making it very specific, or not received within 30 days of the invoice being due, right? You need to specify it further, that, at least you have to give them one chance. Otherwise, you're immediately saying your only recourse is legal recourse. Give a chance. So you have to build that chance in here. Otherwise, what happens is they're veering away from the provisions of the contract. So if it is not provided within the stipulated period, and there is no renegotiation, or the neither party is willing to renegotiate the extension of the stipulated period, then legal recourse is what is available. Do you realize how this is different from what it is here? Stipulated period is not defined in the agreement. It would be. That's why I've used the term stipulated period, because it would be your SOW, or your SLA, which would lay down the stipulated period. This being a clause of the master services agreement, it would use it generically like a stipulated period. So if under an SOW I have been given 10 months to deliver something and I fail to do that, that's my stipulated period. So now I need to either A, enter into a negotiation whereby I'm extending the 10-month period, or B, I'm going to reduce the price. Something, there has to be a mitigation. Legal recourse is not the automatic option. As I told you, and I will keep repeating this sentence ad nauseum, with our contracts, we want to stop our clients from having to resort to litigation all the time. We want them to be able to resolve the problems peaceably without resorting to litigation. Fire prevention, not firefighting. So that is why within this liability clause, typically after discussions with the client, I would insert, or I would encourage the client to consider things like, negotiate an increase in time, decrease the amount of price, that you're charging, or the stipulated time is extended due to issues on their side, you need to bring it up in advance, so on and so forth. Exactly, restructure the deal to a certain extent. That restructuring should be provided for within the particular liability clause, right? It makes it very important, and this is where 90% of the litigations arise from. So we want to reduce it. That's why liability clause is something where you keep encouraging the client to think, okay, if this doesn't happen and you're saying legal recourse, remember this goes into an ambit. for about 3 years, 4 years. Are you sure you want to go down this road, right? Terms of settlement is also a solution. Terms of settlement with regards to what? Are you saying this is your mediation terms of settlement? Restructuring, yes. Restructuring is different. Restructuring is where the contract is still ongoing. You're not mediating. You're negotiating, but not in a formal manner. You're basically buying time. It's like you haggling with your professor, saying, "I need 5 more days to do my homework, ma'am," or "I need 3 more days to get ready for the exam, ma'am." That is exactly what is happening here. So you need to realize that when we are talking about restructuring, it's not so formal as though it's a negotiation. It's more like bargaining and sort of trying to put that in uh, to give you the breathing space you need to get the work done, right? Uh, is that clear? Have I answered all the questions? Okay. So let's move on to the next one. So guarantee and warranty. So one of you had asked me what is the warranty clause and what is the guarantee clause. So I told you that warranty is a representation, right? So for example, at IFIM, we represent that we will provide you with the best legal education possible within the parameters of the university syllabus, right? So you need to realize this is a warranty that we're giving, that we're going to have the best teachers who are going to teach you the best manner possible so that you're able to absorb the law. That's a representation, ergo it's a warranty. When we do not fulfill the representation, it doesn't result in the termination of the contract, it results in damages being due. Understand the difference. So when I say, let's talk about this from a perspective that you might understand. So when you go into a Tanera, sari shops are a bad idea, right? Okay, let's go talk about gold, right? Tanishq. So you go into Tanishq. No, we are not restructuring the agreement. We are restructuring or restructuring, Jojo, is with reference to in extending timelines or tweaking specifics of the contract, which might also involve reducing the price, etc. So it's like almost from the beginning the contract was A, but we changed some of the terms to so it became A version 2, A version 3, so on and so forth. This is after negotiating between the parties, and that is after they have started the performance and they have come across both the problems. Yes, they would generally get signed by both the parties as an addendum to the extending existing contract, existing SOW, right? And therefore it would need to be signed by both the parties. Generally nowadays, though, the court does accept email, conversations or letters being exchanged with regards to these negotiations as also proof that you can utilize. Okay. So very quickly, so warranty is basically a representation, and when you breach a warranty, it results in damages. It doesn't result in termination. What do I mean by that? So when you walk into a McDonald's, right? McDonald's has these sort of quality rules that it represents. You will see its quality policy somewhere, providing customers with hot, nutritious, highly fattening. They should have mentioned that food at McDonald's, right? And with optimum cheerful service with minimum time. Something to that effect would be their quality policy. That's a representation. That's the warranty that they're giving you, that this is what we're going to do. So if you get cold fries, it's not like they're going to, immediately pay you, all your money back and say, don't worry about the food. No, they're not going to do that. Remember your thumb in the Coke case? You can sue for damages. You can absolutely sue for damages. You can ask for compensation for the mental agony and anguish associated with it, right? So, warranty is more like promises, yes, a representation and a promise, right? Guarantee, on the other hand, is literally a technical term in law, right? Uh, For most of us, guarantee is associated with, oh, I have a laptop, the screen broke, it's under guarantee, now they will replace the laptop or they'll replace the screen. Yeah, that is not the guarantee that we're talking about here. Guarantee here is the three-party contractual special contract that exists where you have a creditor, a principal debtor, and a surety. And a contract of guarantee or a clause of guarantee basically lays out that if in case the creditor is not paid by the debtor, then the surety will pay up. So in a typical contract, if I am a manufacturer, party A is the retailer. Party B is saying, party A, if he fails to pay, I will pay up. And that's the guarantee provision that can be a part of the contract. Yes. So he's the guarantor. We don't use the term guarantor technically, we use the term surety for the guarantor, right? Uh, so you need to realize that with the difference between warranty and guarantee is exactly that. With regards to warranty, it's representations. With regards to guarantee, it's the payment of the indemnification of a loss in a way. That being said, you need to realize warranty drafting is a very, very important skill because you're basically laying yourself open to liability if in case you do not fulfill your warranty. So for example, if I had promised that, oh, I'm going to make you the best lasagna ever, the tastiest, most well layered lasagna ever, and that's a warranty that is impossible. What is the best? How do you prove that? Is something with truffles the best? Is something with something else the best? You cannot have your clients going overboard with this, and they love to because this is their pitch point. This is where they're selling, right? This is their USP. So they want to bring to the fore their best and the best and the best of their features, and you have to be like, yes, I get it, but you need to tone it down. But you need to tone it down. That's our job, right? So when you're even dealing with your clients, you need to let them know that their representations cannot be impossible. You can't say, oh, I'm going to give you my work with 0% errors. Are you sure you can deliver that? Minimum amount of errors. That's a good number to give. That's a representation that you can stick to. Something that is humanly impossible. Yes. um, I think even the Japanese have achieved 99.9% error freeness. There's still 0.01%, and that's why minimum amount of errors, due care will be taken rather than, oh, excellent care. All the superlatives, box them up back into the thesaurus, throw the thesaurus away. Stick to the cautious language when you're looking at all of the provisions with regards to guarantee, warranty. So here's our Easter egg hunt. Ready for it, guys? So the first one, what do you guys think? Is there an error? So majority are saying yes, there is an error, and one person is saying no, there is no error. There is an error because you can never warrant zero defects. You cannot. That's a representation that opens you up for liability. This is something we would forbid our clients from doing. Very quickly, I'll go over the rest because I think we're running a little low on time. It's already 4:49. I think this session is only till 5:30, so I want to leave some time for question and answers also. So the service provider warrants that all the materials used for manufacturing the goods will be of optimum quality. This is a good sort of general term with the use of good, shall we say, superlatives, which will not commit you to anything, because optimum means what would be best for the price that you are offering, right? So if I am saying that I want, my gold chain to be 5 rupees, chances are it's going to just basically have a gold paint wash. It's not going to be made of gold, right? So optimum quality, when we are saying 5 rupees, if I'm going to manufacture that chain, I will use whatever will fall within that price. So optimum is a good utilization rather than excellent quality, awesome quality, the best quality. Instead of using those terms, optimum means whatever is perfect for this standard. So that is a decent enough warrant. Um, all payments will be made in a timely fashion. This is again just general enough that it will secure you from any litigation, but you don't really want to put this here because timely is timely when it is due, or is timely when it is done being due. What do I mean by that? So if I have a 30-day grace period and I pay on the 29th day, is my representation invalid, right? So you want to say that, these kinds of warrants you would typically discourage from including if you are representing the agency, right? Uh, this is your non-poach clause, right? So basically, where you're looking at industry standards, and para 2 is acceptable. Litigation can be avoided, yes, but I don't know how much you would want to leave that in. When it comes to your the third one, the non-poach. I just wanted to talk to you really quickly about non-poach clauses being in agreements. Typically, in the service sector, this happens. You do not want to allow for a non-poach, but you wouldn't put it in your representations and warranties. You would have a separate core clause called non-poach, um, or basically laying down that you will not poach any of my employees. So you wouldn't put it in a representation and warranty. It would be a separate paragraph all of its own, right? So from that perspective, it's an error. Okay. Moving on. So jurisdiction. This is critical. Very, 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 very important. You need to know what law, so it also comes as applicable law sometimes. So you need to realize there is a difference. Jurisdiction tells you which court you go to, applicable law tells you what law is going to be applied. So that difference can exist in the sense, especially if you have international transactions, you could have an applicable law and the jurisdiction is an international court. So from that perspective, these two are different, but generally in local contracts, we do try to keep the applicable law and the jurisdiction the same. It doesn't make sense to ask, the Bombay High Court to apply, Karnataka's Shops and Establishments Act, right? So yes, it should be more specific. That's why the Utsav's question, sorry, Mr. Biswas's question is, if para 3 is specific, litigation can be avoided. Should not that be more specific? Yes, it should be. It is very common that an employee of Infosys will join Wipro after some time. Yes, and that's why we should have a non-poach clause in all of our service agreements. It's critical. And yes, so coming back to our jurisdiction and applicable law, you need to realize jurisdiction lays down which court and applicable law lays down which laws. Now, you want to make sure when it is a local contract that both are the same and they're very clearly specified. So I have a fun jurisdiction clause. This uh, is from one that I have seen in a contract which was between a party based in Bombay. and a party based in Delhi. I think you can find the biggest Easter egg in this one. Exactly. There is no High Court of India. There is the Supreme Court of India. You need to specify which High Court you wanted to go to. Yes, and this was intended as a joke. So good to see you guys have your sense of humor still. Happy to see that. But please understand, you can't really say laws of India will apply in case of any disputes that arise during the performance of this contract, unless you're entering into an international contract. You would typically mention the state to which you want the laws to apply to, and you would typically specify the High Court. This is a ridiculous jurisdiction and applicable law, clause, and nobody should ever draft it like that, right? Next is our dispute resolution. I think we'd already discussed that this is very, very critical. Now, one of the things that happens is people love to copy and paste dispute resolution clauses, and arbitration agreements do mention the procedure, mention laws and procedures of India. That is acceptable. I am speaking from the perspective of jurisdiction. Jurisdiction, you want it specific because you want Shops and Establishments Act of a particular state to apply to you. You don't want it to be generic, right? In arbitration agreements, you want the arbitration law of India to apply to you. So that is what you follow, right? So that is why it says laws and procedures of India. So that being said, typically in your dispute resolution, I would say you need to ask these questions. Which style of dispute resolution do you want? Do you want arbitration, mediation, negotiation? Why do you want the type of dispute resolution that you're choosing? So arbitration is a little bit long winding. If you're an industry that needs very quick resolutions, then you want to suggest mediation. But if you're a industry that is, or if you're dealing with the government, typically you want to go the arbitration way, right? How? So when should it be invoked, right? And how should it be invoked? So if you're going for arbitration, specify that both parties should choose one arbitrator each, and then both those arbitrators should choose one arbitrator in turn, or mediator should be chosen by both the parties in consonance with each other. When invoked, so you have your liability clauses and you have your termination clauses. Those are the scenarios where you might say that the contract is breached, and in those scenarios you can invoke dispute resolution. Very, very important. And we recently saw a contract where they didn't mention where the arbitration should take place. So it's important. Do we, if it is quiet, if the dispute resolution clause is quiet as to where the arbitration is going to take place, generally we refer to the jurisdiction clause, or both the parties can come to a common consent with regards to it. The problem that happens is if you're already doing arbitration, both the parties are not seeing eye to eye, so chances of them both agreeing to one place is not going to happen. So the smartest thing to do, define it directly in the dispute resolution clause. Don't leave it open to interpretation. Keep it balanced in the sense, don't make your arbitration clause in favor of just your party. Make sure that it allows for the other party to speak, because that becomes a typical ground for challenging an arbitration award, and that is not a good thing, right? So again, Easter egg hunt. If all of you are ready, this is the last one, right? Uh, Come through. Hello, can you all hear me? I'm sorry, I think I got disconnected. Okay, great. So this is your last Easter egg of the day. Can you hear me now? So this is your last Easter egg of the day. Do you see the errors? And this is an executed contract, mind you. We had the wonderful opportunity of perusing it. What do you think? What are the issues? Jurisdiction is vague. Jurisdiction is not mentioned at all. And that became an issue because this contract resulted in a conflict between a party based in Mumbai and another party based in Bangalore. So that became a huge issue. Um, Look at the way it is set up, right? Pune slash Mumbai only, that's a bad idea because it doesn't specify one or the other. Again, as I said, typically with arbitration, you want it to be as clear as possible. You want to make sure that every clause is, fire prevention. This is going to cause more fires because both parties are already not talking, and then you want them to decide between Pune and Mumbai. They're not going to do that. And there is no arbitration acceptance, there's an arbitration award. And in that case, it may be referred to the court is ludicrous because it's like saying you may eat lunch when it's lunchtime. You have to eat lunch when it's lunchtime. When an arbitration award is not to the satisfaction of both the parties, they will approach the court. There is no point in putting in a pointless statement like this. It just lengthens the contract and doesn't add to it in any manner. In fact, it creates more confusion. So, our love to write should not extend to such a point that we start drafting in things that have absolutely, uh, yes, and it should mention that the award of the arbitrator is final and binding, but you also need to realize that however final and binding it is still open for them to exactly, it has a lot of loopholes and we want to make it as loophole-less as possible. I've almost come to the end. Just quickly, confidentiality clause. You need to be very clear with regards to your confidentiality clause. Who does it bind? To whom can they disclose? To whom can they not disclose? What is it that they are protecting? It needs to be very, very clear. And I think we discussed this right at the beginning. Section 34 is always there, yes. Um, you need to be clear when you're drafting your confidentiality clause that not always information is tagged as confidential information. So that is why you need to make sure that you provide for every other situation with regards to this. That's about it. I hope this was a helpful session. If any one of you have questions, now is a good time to ask. Section 34 of Arbitration Act, Arbitration and Conciliation Act. It provides you with recourse to the um, courts. Any questions to me? Should I do a poll for that too? I'm liking this poll thing. It's really cool. Yes. But when we are talking about setting aside, there are certain specific grounds on which it can be set aside. And Yes, only on specific grounds. In case if the agreement is entered on restricted holiday, how to deal with an arbitration matter? Non-poach clauses would have the same time as the term of the contract, Mr. Viswas. So typically, you wouldn't have an extension. However, in some cases, I have seen that they've extended to a year beyond the contract. This is one of those situations where the terms outlive the life of the contract. So they may say even a year after the contract comes to an end, either due to termination or due to the end of the term, the non-poach clause still subsists. So it can have a time period specified in this manner in the service agreement, in the master service agreement. Yes. Uh, and Shweta, I'm trying to understand your question. So if the agreement is entered on restricted holiday, how to deal with an arbitration matter? I'm not able to understand. Are you asking if the agreement is entered into, if the arbitration agreement is entered into, or the arbitration award is given on a restricted holiday? I'm so sorry. If you could explain your question further, Shweta, I can help you with it. So it doesn't matter on which day they have entered into an agreement, right? We are talking about the agreement where both the parties are saying, yes, we are okay with arbitration. If they decide to do that on a restricted holiday, there is really no limitation to that. You have to argue on that issue, though. In what way, sir? It doesn't, I don't see how you could. An agreement may be dated as 15th August. I don't see how that in any way affects the validity of the agreement, even if it's a national holiday. We purchase goods on Amazon or on Myntra, etc. on 15th August too. In fact, they have special sales. Those are contracts we are entering into. They don't become invalid because they are entered into on a national holiday. So I still fail to see how entering into an agreement on a national holiday is in any form questioning the validity of the contract. Oh, the judge was not happy with the idea that a contract was entered into on 15th August. Oh my God, that was hilarious. Oh wow, sir. That sounds amazing. Oh my. I, uh, that would have been an impossible thing to handle. Okay. Thank you everybody for participating. I will update you again with regards to when we will have our next session on the fundamentals of a contract drafting, especially with Mr. Bhumesh Verma. I'm so sorry for his presence not being there. I know I did not in any way measure up to his standards, but I'm hoping you have enough of a foundation to help you through. All the best. Thank you for participating. I hope everything was clear and today we didn't have as many internet issues. So please take care. Please be safe. Wash your hands. Stay at home. Practice social distancing. Bye bye. Thank you, guys. Thank you so much. Good day.